My name is Marcus. I'm 38 years old. I'm a commercial airline captain flying international long-haul routes out of Atlanta. And while I was on a 14-day rotation through 3 continents in September 2025, my ex-wife and her new husband forged my signature on a legal document waiving my parental rights, attempting to finalize a step-parent adoption of my own son before I ever landed back on American soil. I want to show you the exact moment a handwriting examiner confirmed the signature wasn't mine. But first you need to understand how a father who never missed a single custody exchange in 7 years ended up almost losing his son on paper, without ever once being asked. Picture this. A family court clerk's office in Fulton County, Georgia, October 2025. A clerk sliding a filed adoption petition across the counter. My own name listed as a consenting biological parent on a waiver I had never seen, never signed, and never would have signed in 1,000 lifetimes. That's where this ends. Let me walk you through how we got there. If you're watching this, hit subscribe, drop a like, and tell me where you're watching from and what time it is right now where you are. I read every comment, and I promise you, whatever the story sounds like on paper, living through it was far more disorienting than anything I've described so far. I married Renata in 2014, and our son, Diego, was born in 2016. We divorced in 2020, an amicable split by most external measures, with a joint custody arrangement that gave Renata primary physical custody. Given the demands of my flight schedule, while I maintained regular visitation, full decision-making rights as his legal father, and, critically, an arrangement that required my explicit written consent for any adoption or termination of my own parental status, a standard protection built into nearly every custody order in Georgia. I want to walk you through what those years of co-parenting actually looked like day to day, because I think it matters to understanding how blindsided I was by everything that followed. My flight schedule meant I typically had Diego for stretches of 5 to 7 consecutive days each month. Rather than a simple every other weekend arrangement, a rhythm that actually suited us both, Diego got extended, uninterrupted time with me rather than rushed weekend visits, and I structured my entire bidding schedule as a pilot around maximizing those blocks. I never missed a single scheduled custody exchange in 5 years, even when it meant swapping trips with colleagues or taking unpaid time to make sure I was there for his kindergarten graduation, his first little league season, the specific rituals of fatherhood that matter more in their consistency than in their scale. I want to be honest about something from the very beginning of this story, because I think it matters to how it unfolded. Renata and I had a genuinely functional co-parenting relationship for the first 4 years after our divorce. We coordinated schedules without much conflict, attended Diego's school events together when our rotations allowed, and I never once had reason to believe she harbored the kind of resentment that would eventually lead to what happened in 2025. Renata remarried in 2022 to a man named Charles Whitfield, a commercial real estate developer roughly a decade older than her, with 2 adult children from a previous marriage and, by every outward appearance, a genuine fondness for Diego, who was 6 when Charles entered his life. I met Charles several times at school events and custody exchanges, and while our relationship never grew close, it remained civil, even cordial, for the better part of 2 years. Charles owned a successful development firm in the Atlanta suburbs, and I understood, even then, that his financial position was considerably more comfortable than my own captain's salary, though it never once occurred to me that this disparity would eventually become the foundation for an entire legal strategy. The shift began subtly in early 2024, when Charles started attending more of Diego's school functions than either Renata or I did individually, a pattern I noticed but initially interpreted as simple generosity rather than anything more calculated. By mid-2024, Diego had started referring to Charles, in conversations with me, as basically my other dad, a phrase that stung more than I let on at the time, though I told myself it reflected nothing more than a child's natural affection for a stable adult presence in his life. The binary choice moment came in January 2025, when Renata approached me directly, over coffee at a restaurant near Diego's school, asking whether I would consider consenting to Charles legally adopting Diego, framing it as a way to give Diego full security and stability, given Charles's financial position and evident commitment to him. I remember that conversation in specific detail, a small cafe with mismatched chairs, Renata stirring her coffee for a long moment before actually asking the question, as though she'd rehearsed how to phrase it in a way that wouldn't sound as significant as it actually was. She mentioned Charles's estate planning, his desire to include Diego formally in his will and his family's business interests, and framed the entire request as a practical, loving gesture rather than anything that would actually change my own legal relationship to my son. I told her, clearly and without hesitation, that I would never voluntarily relinquish my parental rights to my own son, that Diego already had a father who loved him and showed up for him consistently despite an unconventional work schedule, and that no amount of financial stability from another man changed that basic fact. I remember telling her specifically that if Charles wanted to provide financially for Diego, there were a dozen ways to do that without requiring me to disappear from my son's birth certificate entirely, and that I was open to discussing any of those alternatives honestly, if that's genuinely what this was about. Renata's expression, in that moment, shifted into something I hadn't seen from her since before our divorce. A controlled, careful blankness that I now understand, in hindsight, was the exact moment she and Charles began exploring options that didn't require my actual consent at all. If you've ever had to say a firm, unwavering no to something framed as being for your own child's benefit, you understand exactly the impossible position I'm describing. Drop a comment if you've lived some version of that. Through the spring and summer of 2025, my relationship with Renata cooled noticeably, communications growing shorter and more transactional, though custody exchanges continued without any overt conflict. Looking back now, I can identify specific moments that should have registered as warning signs. A conversation in April where Renata asked, seemingly offhand, exactly how my September flight rotation was structured, information I shared without a second thought, since we'd always coordinated schedules openly as part of managing Diego's care between us. A comment from Diego in June, mentioning that Charles had taken him to meet a nice lady at an office for what Diego described, in the vague way 6-year-olds describe adult errands, as boring paperwork stuff, a detail I dismissed at the time as some unremarkable adult task rather than what I now believe was likely an early visit to establish the notary relationship that would later be exploited. I flew a sequence of long-haul routes, Atlanta to Frankfurt, Frankfurt to Dubai, a rest cycle, then Dubai to Singapore and back through Frankfurt again, a rotation that kept me almost entirely unreachable for stretches of 18 to 20 hours at a time, exactly the kind of schedule that, I would later realize, made September 2025 the ideal window for whatever Renata and Charles had already begun planning. What I didn't know until my return was that in early September, Renata and Charles had retained a family law attorney to file a step-parent adoption petition, a process that, under Georgia law, requires the consent of the biological non-custodial parent unless that parent's rights have been separately terminated through a contested court proceeding, an entirely different and far more difficult legal path. Rather than pursuing the difficult, contested route, the petition filed with the court included a signed consent and waiver document, dated September 8, 2025. A date I was mid-flight over the Atlantic Ocean, fully documented in my own airline's flight logs, bearing my full legal signature, notarized by a notary public whose stamp appeared on the document alongside a witness signature I did not recognize. I discovered this only after landing back in Atlanta in late September, when I attempted to schedule my next custody exchange with Diego and received, instead, a brief, oddly formal text from Renata suggesting we let the lawyers handle communication going forward. I remember reading that text standing in my kitchen, still in my uniform, exhausted from the rotation, feeling a confusion that took several minutes to sharpen into real alarm. We had never needed lawyers to handle a simple custody exchange in 5 years of co-parenting. The formality of that message alone told me something significant had shifted while I was unreachable. Confused, I called my own family law attorney, a man named Desmond Cole who had handled our original custody agreement, and asked him to check the court docket for any recent filings. I remember pacing my living room during that call, Desmond's voice going quiet on the other end of the line in a way that, even before he told me anything specific, made my stomach drop. What he found stopped me cold. An adoption petition, filed weeks earlier, listing my own name as a consenting party, with a waiver document attached bearing what appeared to be my signature. I remember sitting in my car outside Desmond's office, reading a scanned copy of that waiver on my phone, staring at a signature that looked, at a casual glance, almost exactly like my own, and feeling something in my chest go cold and very still, the exact sensation, I imagine, of watching the ground shift beneath something you'd always assumed was solid. I had never signed that document. I had never even seen it before that moment. And according to the date printed at the top, I had supposedly signed it while 35,000 feet over open ocean, a fact my own employer's flight records could prove beyond any reasonable dispute. I called my chief pilot that same afternoon not to explain the full situation, but simply to request a certified copy of my flight duty logs for the relevant dates. A request he processed within the hour once I explained, in general terms, that I needed them for an urgent legal matter. Reading through those logs myself that evening. My own name, my own employee number, timestamps showing me actively in command of an aircraft over the Atlantic at the exact hour the waiver claimed I'd been sitting across from a notary in a Georgia strip mall. I felt something harden in me that hadn't fully been there in the initial shock of discovery. This wasn't a misunderstanding. This was a plan, built deliberately around my physical absence. If you've ever discovered that people you once trusted completely had tried to erase your legal relationship to your own child without ever asking you directly, you understand a very specific, bottomless kind of fear. Tell me in the comments if you've experienced anything close to it. Desmond moved immediately to file an emergency motion to stay the adoption proceeding, attaching my airline's official flight manifest and duty logs showing conclusively that I had been on an active international flight, physically incapable of appearing before any notary in Georgia, on the exact date the waiver claimed I had signed it in person. The court granted the emergency stay within 48 hours, halting the adoption process pending a full investigation into the document's authenticity. Desmond retained a certified forensic document examiner, a woman named Harriet Okafor, to formally analyze the signature itself. Her report, delivered 3 weeks later, confirmed what the flight logs alone had already made clear beyond reasonable doubt. The signature on the waiver, when compared against 11 verified samples of my own signature from various legal and financial documents over the preceding 5 years, showed consistent structural inconsistencies characteristic of forgery, including pen pressure patterns and letter formations inconsistent with natural, unhurried signing. Harriet's investigation also extended to the notary who had stamped the document, a woman named Dolores Fenner operating out of a shipping and notary store in a strip mall roughly 15 minutes from Renata and Charles's home. When Desmond's investigator contacted Dolores directly, she initially insisted she remembered notarizing the document with me present. But when shown my airline's flight documentation proving my physical absence from the state entirely on that date, she grew visibly uncertain, eventually admitting she may have notarized the document based on a photo identification presented to her rather than requiring the actual signer's presence. A serious violation of Georgia notary procedure that would later result in the suspension of her notary commission. Desmond's investigator pressed further, and Dolores eventually recalled that a man matching Charles's general description had come into the store alone, presenting what he described as his stepson's father's identification along with the pre-signed document, explaining that he was in a rush and couldn't make it in personally. Dolores, by her own admission, had processed dozens of documents that week and hadn't thought twice about accepting a document already bearing a signature rather than witnessing it executed in front of her. A shortcut that violated her notary training but that she'd apparently grown lax about over years of routine, low-stakes small business notarizations. If you've ever had to prove, using science and logistics records, that your own signature on a document affecting your child's legal identity was a lie constructed by people who once claimed to love you, you understand a violation that goes beyond ordinary betrayal. Drop a comment if you've felt anything close to it. Desmond's investigation moved further, subpoenaing communications between Renata, Charles, and the attorney who had filed the adoption petition on their behalf. One email, sent from Charles to that attorney in late August 2025, read in part, "Marcus is going to be unreachable for most of September on his rotation schedule. If we can get this filed and processed quickly while he's out of contact, by the time he's back and paying attention, it should already be finalized, and contesting a completed adoption is a much harder legal road for him than stopping one in progress." I read that email sitting in Desmond's office, and I want to tell you my first reaction was rage, but what actually settled over me first was a strange, disorienting grief. The sense of understanding in writing that the mother of my son had knowingly built a plan around exploiting my absence rather than simply asking me, honestly, why she and Charles wanted this so badly in the first place. I remember asking Desmond, in that meeting, whether the attorney who filed the petition bore any responsibility for proceeding without verifying my actual consent independently. Desmond explained that family law attorneys generally rely on the documents their clients present to them as genuine, and that unless the attorney had specific reason to doubt the waiver's authenticity, the greater legal exposure rested with Renata and Charles themselves for knowingly submitting a fraudulent document, regardless of who had physically produced the forged signature. The court scheduled a full evidentiary hearing for November 2025 to address both the fraudulent waiver and the broader adoption petition itself. I want to walk you through that hearing carefully, because I think the specific unraveling of it matters. Harriet testified first, presenting her forensic signature analysis alongside my airline's flight documentation, establishing beyond any reasonable dispute that I had been physically incapable of signing the waiver on the date claimed. She walked the court through her methodology in careful, technical detail, comparing letter slant, pen pressure variance, and the natural rhythm of stroke connections across my 11 verified signature samples against the waiver's signature, concluding with what she described as a confidence level leaving essentially no room for the signature having been genuinely mine. Dolores Fenner testified next, under subpoena, admitting she had notarized the document without requiring my actual physical presence, a clear violation that undermined the waiver's validity entirely independent of the forgery question. She appeared on the stand, genuinely remorseful, explaining to the court that she had processed the document quickly during a busy afternoon, never imagining the consequences her shortcut might eventually carry for a father's relationship with his own son. Judge Vance noted, for the record, that regardless of Dolores's lack of malicious intent, her negligence had directly enabled a serious fraud against the court and against me personally. When Renata took the stand, Desmond's cross-examination focused on a single, direct question: whether she had known, at the time the petition was filed, that the attached waiver document did not bear my genuine signature. Renata's composure, which had held through most of the proceeding, finally broke at that question. "I told myself Charles handled the legal details," she said, her voice unsteady. "That whatever paperwork his attorney needed, it wasn't really my responsibility to verify each piece myself. I think, if I'm honest, some part of me knew something wasn't right about the timeline, how quickly it all came together right when you'd be gone, but I let myself not ask too many questions because I wanted Diego to have what I believed was more stability than you and I could give him between two households. I convinced myself the ends justified whatever shortcuts got us there. It wasn't a full admission of participating in the forgery directly, but it was the first entirely honest accounting Renata had offered since any of this began, and I noted it quietly the way I've learned to note everything since September." Desmond pressed further, asking Renata directly whether she had ever considered, at any point in the process, simply asking me again, honestly, why she and Charles wanted this so urgently, rather than proceeding around my absence. She was quiet for a long moment before answering. "I think some part of me knew you'd say no again," she said, "and I didn't want to hear it a second time. It was easier to let Charles handle it than to face you directly and risk you being right. I didn't have a response to that in the moment. I still don't fully, though I understand the shape of it better now than I did sitting in that courtroom." Charles, called to testify after Renata, admitted, under direct questioning about the recovered email, that he had specifically timed the filing around my flight rotation, and that he had arranged for the waiver document to be signed by someone other than me, though he stopped short of naming who had actually produced the forged signature, citing his own pending legal exposure. Under further questioning, Charles acknowledged that he had personally delivered the document to Dolores's notary office, though he maintained, without much conviction, that he believed at the time the signature had been genuinely obtained, an explanation Judge Vance noted in her ruling she found difficult to credit given the surrounding circumstances and the recovered email's explicit language about timing the filing around my absence. The judge, a measured, clearly unimpressed jurist named Colette Vance, noted for the record that regardless of who had physically forged the signature, both Renata and Charles bore responsibility for knowingly submitting a fraudulent document to the court in pursuit of terminating my parental rights without my consent. Judge Vance dismissed the adoption petition in full, referred the forgery and notary fraud findings to the district attorney's office for potential criminal charges, and, in a passage I've read more times than I probably should admit, noted in her written ruling that few actions available to a family court carry graver consequences than the fraudulent termination of a fit parent's legal relationship to his own child, and the court finds the conduct here to be a serious and troubling breach of both this court's trust and the petitioner's most basic obligations as a parent. In the months since that ruling, my custody arrangement with Diego has remained fully intact, unchanged from our original 2020 agreement, though the relationship between Renata, Charles, and myself remains, understandably, deeply strained. Diego, now 9, doesn't fully understand the legal details of what happened, and Renata and I have agreed, at least for now, to shield him from the specifics until he's old enough to process them without confusion about who actually fought to remain his father. I've had a lot of time since November to think about what actually drove Renata to go along with this, beyond the simple financial calculus of Charles's greater wealth. I think, in some way, she genuinely believed she was giving Diego something better, a two-parent household with more resources and more stability than our own split custody arrangement could offer, and I think that belief, however misguided in its execution, came from something that wasn't purely malicious. That understanding doesn't excuse what happened. It just helps me hold both things at once. My own anger at nearly losing my son on paper, and some fragment of compassion for a woman who convinced herself a shortcut was justified by a goal she genuinely believed in. The district attorney's office, as of this recording, is still reviewing the forgery and notary fraud findings for potential criminal charges against Charles specifically, since the evidence most directly implicates him as the person who physically delivered the forged document to Dolores. Renata's own legal exposure remains under review as well, given her admitted awareness that something about the process felt wrong even as she chose not to examine it too closely. I keep coming back to a simple, painful truth underneath all of it. Renata and Charles never needed to forge anything at all. All they ever had to do was ask me why this mattered so much to them, and give me the chance to understand and possibly even support some version of Charles's role in Diego's life through means that didn't require erasing me first. Instead, they chose a shortcut built on my absence, and in doing so, very nearly cost themselves everything they claimed to be protecting. Diego and I had a rotation together just last week, 5 full days, the longest stretch we've had since before any of this began. We built a model airplane together on the second night, one of those detailed kits I'd been saving for a milestone birthday, and at some point he asked me, without any particular weight behind the question, why I'd been so busy with boring grown-up stuff the past few months. I told him simply that sometimes grown-ups have to work hard to make sure everyone in a family gets treated fairly, and that I loved him exactly as much as I always had, through all of it. He seemed satisfied with that answer, the way 9-year-olds usually are, with an honest answer pitched at exactly the right size for what they're actually ready to hear. I think if you've made it this far, the thing worth remembering tonight is this: being unreachable, being far away, being asleep at 35,000 feet over an ocean, does not make a father's consent unnecessary, and no amount of financial stability or good intentions from anyone else ever justifies erasing a fit parent from his own child's life without his knowledge. If you are a father who has ever felt like your voice mattered less because of distance, a work schedule, or someone else's convenient timing, you are allowed to demand that your consent actually means something, and the record, examined carefully enough, will always tell the truth about who was actually there and who only pretended to be. If this story meant something to you, subscribe, drop a like, and tell me where you're watching from. Share this with someone who needs to hear it. I'll see you in the next one.